how can you make an informed decision on this without those very important details about the murders themselves? Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, we've been going through the huge document drop, and as you can tell, hopefully, I've decided to do it document by document. So this next one on the list is the state's objection to defendant's motion to strike the HAC aggravator, which is where they are claiming that a crime is being described as heinous, atrocious, and cruel. State's objection to defendant's motion to strike HAC aggravator comes now the state of Idaho by and through the Latell County prosecuting attorney and hereby objects to defendant's motion to strike the HAC heinous, atrocious, and cruel aggravator. For the following reasons, defendant's motion should be denied. Argument. It is well established that a capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. And they cite Lowenfield versus Phelps from 1988 and Zant versus Stevens from 1983. In a companion motion filed contemporaneously with this one, defendant correctly acknowledges that the Idaho Supreme Court has held that Idaho's capital sentencing scheme meets that standard. And it says to see the defendant's motion to strike utter disregard aggravator, which is another set of arguments that we're going to be going over separately, and states that they cite State versus Wood from 1988. As the Idaho Supreme Court explained in Wood, this court has upheld the constitutionality of its death penalty statutes on numerous occasions. Nevertheless, the defendant advances two arguments. First, he argues that the court should find that the gloss placed on the HAC aggravator by the Idaho Supreme Court was in violation of the Idaho Constitution, and we have our first footnote. It states, defendant specifically requests that this court should find that the gloss placed on the aggravator by the Idaho Supreme Court. I'm so tired of seeing this. And like the court clerks in the email from me sending off the FOIA form were so nice. And now I feel like bad. But the fact that there are so many errors in these court documents is just bewildering to me. Because court is not spelled C-O-U-E-T. And we know that you're talking about the Idaho Supreme Court because you're talking about it in the paper. Okay. But Article 2 of Idaho's Constitution does not have a Section 2. Thus, the state presumes from context that the defendant intended to cite to Article 2, Section 1 of the Idaho Constitution to advance a separation of powers argument. So while I'm sitting here saying, actually, this is actually so ironic. So as they're sitting here claiming that the defense cited Article 2, Section 2, and Section 2 doesn't exist, so they must have meant Article 2, Section 1, they're also sitting here misspelling court. As they're trying to be like, oh, they got something wrong. Well, you misspelled court. Second, he asserts that the Idaho Criminal Jury Instructions ICJI for the HAC aggravator does not contain the necessary limiting construction set forth by the Idaho Supreme Court in State versus Osborne. For the reasons set forth below, both of defendants' arguments fail. This court cannot overrule the Idaho Supreme Court. As a threshold matter, this court cannot overrule the Idaho Supreme Court. The Idaho Supreme Court ambiguously set forth its authority in State versus Guzman. To this court falls the obligation to be and remain the ultimate authority in fashioning, declaring, amending, and discarding rules, principles, and doctrines of precedential law by application of which the lower courts will fashion their decisions. This court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. My brain saw promulgated coming up and instantly started spazzing out. It took me forever to be able to pronounce that word correctly last time. I cut a lot of things out. Okay. Just trust me. Okay. Then it goes on to State versus Guzman from 1992, because defendants' argument that this court should hold unconstitutional the Idaho Supreme Court's limiting construction set forth in State versus Osborne requires this court to effectively overrule a higher court. The court should disregard it outright. So basically, because it's claiming you would have to say that what you say means something more than what the Supreme Court says, and that's just not going to happen because the Supreme Court rules. So this is pointless, and you should just be like, no. That's basically what this says. When it comes to the facts of this case, when it comes to how we're hearing the bodies were found, how 4 people were killed, how we've heard everything, this is a heinous, atrocious, and cruel crime. It doesn't matter that I personally feel like they have the wrong person at this moment. What this crime is should not be taken away from. That's the only reason y'all are hearing me like this on this one, because I don't agree with what they're trying to do, and minimizing the facts, minimizing what happened should not be the way that they want to go about this. I know damn well they could have done this another way. They really could have. But then again, all of this is technical. All of it's technical. I said this in a video where I was reviewing a theory here in the true crime community. Some of you guys are here and reading, listening to these document videos, but a lot of you that do that and go for documents and facts, y'all don't really get into the theories and all the crazy stuff, okay? And I mentioned this in my reaction to a theory here recently, that as much as they're trying to go on and on and on about whatever they think is happening, they're still not saying who walked in that house, who took those people's lives, and how Bryan Kohberger's DNA got on that knife sheath that was found on the bed. Because the defense is not stating it's not Bryan's. They know it's Bryan's. What they want to know is how it got there, who put it there. They're not claiming it's not his. You're lying. They want to know why it's there, okay? That matters, and that has to be taken into account when we're talking about this case, when we're talking about case speculation and theory. And a lot of people seem to forget that when they start going on and on about stuff. You cannot go away from the facts. You just can't. As little as we do have, you cannot act like they don't exist because it doesn't fit your narrative. The truth is the truth, regardless of if you like it or not. But I really, really wish the defense would come on with a Frank's motion. I want to know if they have an alternative theory. I want to know what all of the work that they've done has told them, because there's no way, if Bryan Kohberger is truly, truly innocent, like Anne claims to know is a fact here, okay? And the way that she says it in court, I believe her. I don't really feel like it's an act. I really feel like she wholeheartedly believes that, and I could be wrong. But for their big, huge expert witness to come out and claim that everything that he is currently seeing is exculpatory, I wonder if they do have an alternate theory, if they've gotten anything from whatever is apparently also exculpatory from Bethany, along with all of the other data that they've gathered and had to go over and looked at and put together. I want to know what they think actually happened, if Bryan is actually innocent, because they've got to think something by now, right? Okay, let's get back to this. B, the constitutionality of the HAC aggravator has repeatedly been upheld. As defendant acknowledges by his citation of State versus Osborne, the state Supreme Court has upheld the constitutionality of the HAC aggravator with a limiting construction. And it cites the motion to strike HAC that was posted by the defense. And this is them citing the citation from the defense from State versus Osborne from 1981. In adopting the limiting construction placed on the HAC aggravator, the Idaho Supreme Court followed the standards set forth by the United States Supreme Court in Godfrey versus Georgia. In Godfrey versus Georgia, the Supreme Court held that were statutory provisions concerning aggravating circumstances such as these could be applied to any murder. A limiting construction is indispensable if the state is to meet its constitutional obligation to tailor and apply its law in a manner that avoids the arbitrary and capricious infliction of the death penalty. This is quoting Godfrey versus Georgia from 1980. Adopting language utilized by the Florida Supreme Court, the Osborne Court held that heinous means extremely wicked or shockingly evil, that atrocious means outrageously wicked and vile, and cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. What is intended to be included are those capital crimes where the actual commission of the capital felony was accompanied by such additional acts as to set the crime apart from the norm of capital felonies. The conscienceless that's a hard one. The conscienceless or pitiless crime, which is unnecessarily torturous to the victim. Well, see, then you also kind of want to be like, well, then maybe you should take away the HAC aggravator, because from what we're hearing so far, they're trying to claim that all of the victims passed away fairly quickly. The defense and the state, they both have the autopsy results, they have the photos, they have the times of death, they have the cause, the means, all the things, right? And they've still come out pretty much and said that it was pretty quick. You know, from start to end, it was fairly quick. So yeah, I guess honestly, as much as again, I don't like how it's trying to like minimize what really happened here. If the verbiage really is about like being torturous, if it was done quickly, then that's not true. That's the opposite. So yeah, even in the theory that they have, which makes no sense, of one guy, one weapon, 3 stories in the middle of the night in the dark, all the crazy stuff. Okay, Mr. Ninja, it didn't happen that way. There's no way. With no blood trail anywhere, nothing to tell the 2 surviving roommates that there was a bloody situation behind Xana's door, nothing to make them see a trail of blood leading between Xana's bedroom and upstairs where Maddie and Kaylee were eventually found. Because it seems like they weren't even a fleeting thought in the very beginning of it, which is insane to me. But they're claiming that this happened rather quickly, which means there's no time for any of these things. So I guess, even though I don't like the fact that it still makes it feel as if the defense is trying to minimize what actually happened here, if the way that the victims died is accurate to what we've been told so far, then I do have to agree that all of the things that fall into the language used in this for heinous doesn't match what we've heard so far. So again, as much as I don't like how it tries to like degrade the situation, they're not wrong. So, okay. The Osborne Court also adopted language from the Nebraska Supreme Court defining exceptional depravity. In interpreting this portion of the statute, the key word is exceptional. It might be argued that every murder involves depravity. The use of the word exceptional, however, confines it only to those situations where depravity is apparent to such an extent as to obviously offend all standards of morality and intelligence. That's pretty deep. Okay. The Osborne Court explained that with a limiting construction, the HAC aggravator is sufficiently definite and limited to guide the sentencing court's discretion in imposing the death penalty. Decades later, in State v. Hall, the Idaho Supreme Court affirmed the constitutionality of the HAC aggravator, and they cite State v. Hall from 2017. The court held that the appellant had provided no basis, principled or otherwise, to support his vagueness challenge, and noted that the HAC aggravator has been determined constitutional time and time again. And then it looks like we have a second footnote, and it states, notably, the Ninth Circuit Court of Appeals has also found Idaho's HAC aggravator to be constitutional. See Levitt versus Arave from 2004. In fine, taken as a whole, Idaho's delineation of the meaning of heinous, atrocious, or cruel aggravation is sufficient to guide the discretion of the sentencer. I mean, the word shouldn't be that difficult to define. Come on now. Defendants' argument that the Idaho Supreme Court's decision in Verska versus St. Alphonsus Regional Medical Center reversed its ability to provide judicial interpretation to statutes is self-evidently wrong. You're just wrong. I don't care. It's just self-evident. You're just wrong. You should have just known that you were wrong. Jesus. Calm it down, Santa. And it says to see the defendant's motion to strike the HAC aggravator for what they're so wrong about. And in a passage quoted by defendant himself, the Idaho Supreme Court merely explained that we have never revised or voided an ambiguous statute on the ground that it was patently absurd or would produce absurd results when construed as written, and we do not have the authority to do so. The Verska Court simply stated that the court could not rewrite ambiguous statutes. The Verska Court could not limit the court's ability to interpret statutes or add judicial gloss to statutes. Indeed, in Hall, decided 6 years after Verska, the Idaho Supreme Court reiterated the propriety and importance of the HAC limiting construction, holding that the limiting construction and the HAC aggravating circumstance as a whole have repeatedly been interpreted by this court as constitutionally sufficient. So they're basically claiming, as many times as this has been talked about and argued, nothing's changed. It's not going to change now. It has been talked about, fought about several times, and nothing ever changes. Defendants' constitutional claims therefore fly in the face of well-established precedent and should be disregarded by this court. On to C, and it looks like we're going to have this little chart to look at. The ICJI for the HAC aggravator appropriately reflects the case law. Defendant argues that ICJI 1713, the instruction for the HAC aggravator, does away with the additional proofs set forth in Osborne. That is wrong. A comparison can be found below. Okay, let's take a look. State versus Osborne says, what is intended to be included are those capital crimes where the actual commission of the capital felony was accompanied by such additional acts as to set the crime apart from the norm of capital felonies. Okay, so the state now wants to remove one of their aggravators for the reasons why they want the death penalty, which wouldn't that now mean that that falls under that because they're taking away one of those additional acts? The state is. So if they're doing that, I don't know why they're objecting to this. That's where I'm at so far. In the comparison, it states the ICJI 1713 rule states the terms heinous, atrocious, or cruel are intended to refer to those first-degree murders where the actual commission of the first-degree murder was accompanied by such additional acts as to set the crime apart from the norm of first-degree murder. So this one over here, State versus Osborne, is just capital felony. And over here for the ICJI, it's actually listed as first-degree murder. Okay. The State versus Osborne says heinous means extremely wicked or shockingly evil. And the ICJI states a murder is heinous if it is extremely wicked or shockingly evil. It's the same thing. Okay. Atrocious means outrageously wicked or vile, which is the same thing as heinous. So why are they making it like it's a separate thing? Because if heinous and atrocious are going to mean wicked and vile, outrageously and extremely, like seriously, what kind of levels are we going on here to where these two things need to be separate? I'm sorry, that does not make any sense. They are legitimately twins, okay? Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. Basically, like a narcissist, but in this term, it's physical pain, not just emotional and mental. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. It's the same thing, okay? It might be argued that every murder involves depravity. The use of the word exceptional, however, confines it only to those situations where depravity is apparent to such an extent as to obviously offend all standards of morality and intelligence. Meaning, if I would see it, I would probably be taken aback. My morality would be hit and I would lose a little bit of my innocence is how I am like interpreting that. Okay. Right. It might be thought that every murder involves depravity. However, exceptional depravity exists only where depravity is apparent to such an extent as to obviously offend all standards. It's the same thing. So yeah, I mean, it's wrong. He said, defendant argues that ICJI 1713, the instruction for the HAC aggravator, does away with the additional proofs set forth in Osborne. They're literally the exact same. The only difference, like we noticed, is that this says capital felonies and this one says first degree murders. Everything else is literally identical. Okay, so then it says to see State versus Osborne again, and then it says to see Idaho Criminal Jury Instruction 1713, and then there's a link, and again, a link for this direct document will be in the description box as always. And then it states the language of ICJI 1713 is nearly identical to the language in State versus Osborne. Yes, it is. Defendant's argument that the Idaho Supreme Court has somehow changed the wording of the HAC aggravator within the body of ICJI 1713 is flatly wrong and should be disregarded entirely. I am sorry, but I agree. Everything we just read are literally, it's all identical. Conclusion. Defendant's constitutional claims are foreclosed by well-established case law, and his motion is legally meritless. It should be denied. Signed, Egrid Beatty and William Thompson Jr. So I guess I'm just going to end this by going back over what I basically have said already, but a little bit more polished, I guess, now that I'm thinking about it more. Like I said, the state and the defense have all of the exact same paperwork when it comes to the autopsies, the information for how each victim died, the weapon, what it did to them, how it caused their deaths, everything, okay? They have all of it, and it should all match. All of it should match. So for the defense to want to come out here and remove the HAC aggravator after listening to all of the definitions to the words, if the story that we have been told this whole time about it being a very quick situation is actually true, then there would have been no time for torture, there would have been no time to inflict pain, to enjoy suffering, any of those things. There just wouldn't be. There just wouldn't be. These were apparently quick, to the point, job was done situations, right? So if that is the case, then the defense wanting to remove it makes actual complete sense. And even though whenever I was first listening to these arguments and I was first reading these arguments, I took it as if they were trying to minimize what actually happened here, when you go into the very specific definitions of the terms, then the defense is actually correct. The crime doesn't fall into that category. But then we have the state wanting to keep it. And one of their, honestly, their actual biggest arguments in this entire thing, honestly, is that everything that this defense argued was wrong. And from what it looks, how it reads, they're not wrong in the things they're claiming the defense was wrong about. I mean, they proved their fight. They proved their point. But none of it was regarding the actual case itself. None of it was regarding actual case fact about the crime and the murders themselves. So I honestly find these arguments to be sort of stupidly pointless. Now, don't get me wrong, I'm going to finish my videos going over these arguments. But unless they're coming in here and talking about wounds and how the deaths actually played out, how can we actually know whose argument is correct here? How do we know who's right in claiming heinous, atrocious, and cruel doesn't matter when it comes to this, because that's not what happened here, or the person who's claiming that it does? How are we supposed to know who's right and who's wrong? Is there some sort of like sealed edition to these with that information on it that also gets like submitted so that the judge can read like the facts before he makes a decision? Because how can you make an informed decision on this without those very important details about the murders themselves to determine if they actually fall under the actual factual definition of heinous, atrocious, and cruel? Wouldn't you need that, like, as a basis for that argument? All they're doing is talking about other cases and what those other cases argued. What about the facts of the case? So then you have to think about it. Why would the state want to keep this if we're being told this was a quick situation? There would have been no time to save anyone, which we don't even know if that's true. And we have to go back to the story that we heard from Kaylee's mom whenever Christy went on and talked to Daniel with Drunk Turkey. This was a very long time ago. We've talked about this several times on this channel. But the story that she was told was that Hunter Johnson, Ethan's best friend, had to come over and get the door open to Xana's room because Ethan's body was wedged up against the door and they couldn't open it. There was literally no talk at all about Kaylee or Maddie until after the first responders apparently got there and asked the people if anyone else lived in the house, which, from what we've heard, the 2 bedrooms were gruesome and horrible, okay? But there was apparently no indication of there being 2 crime scenes. But then again, I've also wondered why Hunter Johnson was called over instead of the 2 adult women upstairs being called down to help get the door open. So whenever you consider both of those things, it's pretty contradictorial. I don't really understand which way to think about it. But that's the story that a mother of one of the victims was told. And you can't sit there and tell me that this was quick and to the point and there was no, time to save anyone. If that door was closed and Ethan was wedged against it, that would probably mean that he was alive after the door closed and moved towards the door before he passed away. How else would you get wedged in that situation? And there's no way I'm going to sit here and believe that a camera that was 50 feet outside of Xana's window picked up whimpering. Whimpering is a closed mouth noise. It is low decibel. You are not picking that up from just anywhere, okay? And thuds from a camera outside, and never mind the fact that apparently, according to what the report is, Dylan claims to have heard someone say something along the lines of "it's okay, I'm gonna help you," or something like that in a normal tone of voice. So you can hear someone speaking something normally, but you can't hear 4 people fighting for their lives? Freaking possible. There's nothing that's going to make me believe otherwise. So then it leads to the 8-hour delay in the 911 call and circles back to maybe this wasn't so quick. Maybe it really was all of the things that fall under heinous, atrocious, and cruel, and it wasn't as quick and to the point with no time to save anyone like we were told. We still have at least a year before we find out anything when it comes to any of those questions. So for now, we're just going to keep going over these documents and thinking about facts and theorizing off of said facts. But I want to know what you guys think about this argument down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And don't forget to make sure that your notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.